Hi, I'm Jane Dearwester with McIntyre Elder Law. When we meet with clients who are starting their estate plan, often people come in with an idea of whether they want a will or a trust. And most of the time, maybe about 90% of the time, people come in thinking they need a trust and they may not really need a trust. Now, if you really want a trust, we are happy to draft one for you. But at McIntyre Elder Law, we are going to tell you what we recommend based on your specific needs, assets, desires, and on your family structure. So there is no one size fits all for estate planning. Every client that we meet with has an absolutely unique situation, and we really customize our advice to each and every individual client. So where a will may be perfectly great for one person, person number two, a trust is going to be better planning for them. So the difference between these two documents is substantial. They're two very different things. A will is a document where you name an executor. This is a person who is going to marshal your assets after your death. This person needs to be very detail oriented, so you need to think about that before you name this person in your will to serve as your executor. We also recommend you name at least one backup person, maybe even two backup people. That just extends the longevity of your document. So if one person predeceases you or isn't able to serve for whatever reason at the time of your death, you've got some backup options in place. I also highly recommend that you speak with the person that you're naming to be your executor, because if you never talk to them about it and after you pass away they decline to serve as your executor, then all your estate planning was kind of for naught. They don't have to serve. Nobody can force them to serve as your executor. It really is something they have to do voluntarily. So please have a conversation with your loved ones, the person you would naturally think you want to serve in this capacity. Please have that conversation long before your death. And a trust is something different. A trust is a more private document, where a will is a document that gets filed at the courthouse after your death. A trust is never filed at the courthouse. So trust, for people that want to keep their final wishes more private, that is a good vehicle. Trust, sometimes you have to give up some control. Not always. You can have a revocable living trust where you still retain power and control over your assets. But again, in some situations, it makes more sense to do a convertible trust or an irrevocable trust. There are various different types of trusts. And again, we're going to fine tune and tailor that to your specific situation. So I would just ask you, when you come in to meet with one of our attorneys, come in with an open mind about your estate plan. Somebody may have told you at church or at the ball game that they just set up a trust and it's the best thing ever and you should do it too. But you and the friend have completely different situations. So please keep an open mind. Take your attorney's advice after full disclosure of everything that you're trying to accomplish. And just know that things may change over time. We advise our clients to revisit their estate plan often and at least annually. So you may set up a will in year one, and then by year 5, things in your life have changed such that in year 5 we say, you know what, now it's time to set up a trust. So estate planning will evolve as your life evolves. So keep that in mind. Keep an open mind when you come in, and talk to your estate planning attorney about all of the different concerns that you have about your assets and your family. Please give us a call to set up a free consultation. We have offices in Hendersonville, Shelby, and Charlotte.